Hello everyone. Today's topic is lifting of corporate veil. Before explaining the topic lifting of corporate veil, let us know what is corporate veil. We know that one of the important characteristics of a company is its separate legal entity. It means that the existence of a company is independent and separate. This separate legal entity creates a veil, that is, a curtain, between the company and its members. This veil is called corporate veil or the veil of incorporation. This corporate veil protects the members of the company from being personally liable for the act of the company. Now we come to the topic lifting of corporate veil. The term lifting of corporate veil means ignoring the status of separate legal entity of a company and treating the company and its members as one person. The separate personality of a company is a statutory privilege and it must be used for a legitimate purpose only. Whenever and wherever this separate personality, that is legal entity of a company, is misused for fraudulent or improper conduct or for doing things against public policy, the appropriate authority will lift the veil of corporate personality and take legal actions against the members who have done or committed such a crime or offense. Now I am going to discuss the grounds under which corporate veil of a company is lifted. Number 1, fraudulent conduct of business. 2, misstatement in the prospectus. 3, failure to repay application money. 4, non-payment of income tax. 5, liability for pre-incorporation contracts. 6, ultra-virus acts. Let us now discuss the above points one by one. Fraudulent conduct of business. Section 339 of the Companies Act 2013 states that the members of the company will be personally liable if they have knowingly incorporated the company with the intention to defraud creditors of the company or any other person or for any fraudulent purpose. Next, misstatement in the prospectus. Section 35 of the Companies Act 2013 states that if the prospectus of a company contains any misstatement, that is, untrue statement, then every director, promoter of the company, and every person who authorized the issue of prospectus shall be liable to pay compensation to every person who has sustained any loss or damages by reason of any untrue statement contained in the prospectus. Next, failure to repay application money. Section 39 of the Companies Act 2013 states that the directors of the company shall be jointly and severally liable to repay the application money with interest within such time and manner as may be prescribed if default is made by the company in returning the application money to the applicant within a prescribed period. Next, non-payment of income tax. When a private company is wound up and the income tax in respect of its income of any previous year is unpaid, in such a case, every person who was a director of the company at any time during the relevant previous year shall be personally liable for the payment of the income tax. Next, liability for pre-incorporation contract. A pre-incorporation contract is a contract which is entered into by the promoters before the incorporation of the company. Sometimes, after the formation of the company, it does not adopt the pre-incorporation contracts. In such cases, the promoters will be personally liable for all such contracts which are not adopted by the company after its formation. The next ground is ultra-virus acts. Ultra means beyond and virus means power. Therefore, ultra-virus act means an act which is beyond the power of the company. The directors of a company will be personally liable for all the ultra-virus acts, even if they are done on behalf of the company. So these are the grounds under which the corporate veil of a company is lifted. That's all for today. Thank you very much.